conference will now be recorded.
Pursuant to Executive Order Number 20-69, issued by the Office of Governor Ron DeSantis on March 20th, 2020, municipalities may conduct meetings of their governing boards without having a quorum of its members present physically or at any specific location and utilizing communications media technology such as telephonic or video conferencing as provided by Section 120.545B2 Florida statutes. Procedures for public comment or providing testimony will be explained by the town clerk. The agenda, the material for each item on the agenda, and the notice regarding the virtual meeting were made available beginning July 2nd, 2020 on the town's website and is also available on the town clerk's office, in the town clerk's office during business hours. The town has developed several new methods allowing for virtual testimony and ensuring public comment for a virtual meeting. Any person may be heard by the special magistrate through teleconference and upon registering with the assistant town clerk. Since this is a virtual meeting as authorized by the governor of the state of Florida, members of the public wishing to address the body may do so by the assistant town clerk will unmute the public for the special magistrate to swear in those participating virtually that will provide testimony. The assistant town clerk will also unmute once the special magistrate has indicated for those participating virtually to provide testimony or to voice their public comment. Persons who cannot access the meeting by teleconferencing using a computer with speaker capabilities or through a smartphone application can call Town Hall at 561-732-2635 and notify a Town Hall staff member of their public comment. The Town Hall staff will notify the town clerk, who shall read the public comment into the record. These public comment options established for the virtual virtual code enforcement meeting comply with sections 286.0114 and section 120.54 Florida statutes. The public that is physically present for the code enforcement meeting may provide testimony or a public comment by coming up to the podium. The town of Ocean Ridge has a face covering requirement and also encourages the public to practice social distance. All chairs within the town hall have been measured to comply with 6 feet social distancing requirement. No-touch hand sanitizer stations have been placed next to the podium as well as next to the entrance doors of town hall. Tips for virtual meetings. Try using only one device. Do not attend the meeting by using both a computer and telephone at the same time, as you will experience feedback with a strong echo and you will not be able to participate in the meeting properly. Mute your phone. If you are attending by telephone or computer, those that do not mute their phones can cause disruptions into the meeting. Do not unmute yourself. If you are attending by the GoToMeeting application or a computer, please do not unmute yourself. The assistant town clerk will unmute persons when indicated by the special magistrate. The information in the chat box is a public record. Call Town Hall if experiencing technical difficulties at 561-732-2635.
Thank you. Good morning. This is the Town of Ocean Ridge Special Magistrate Code Enforcement hearing. Today is July 7th, 2020. We started at 10:11. My name is Amity Barnard. I'll be the Special Magistrate presiding over today's hearing. A little bit about, I think we have some folks, some cases, representatives for some cases outside, so we'll swear each set of people in as we hear the cases, if that's okay with the town.
Yes, Special Magistrate.
Okay, a little bit about how this process works. The agenda this morning looks to be, aside from the minutes, only violation hearing. So essentially how it will work is the town attorney will call the case as it appears on the agenda. The town will present its side. Anybody here on behalf of the respondents will be able to present their testimony, cross-examine any witnesses that the town puts on, ask any questions of me, present any evidence that you wish that I see or hear today as we contemplate these issues. At the end of the dialogue and what usually amounts to a back and forth, I'll make a ruling. There'll be a subsequent order issued which will reflect that ruling. This is a quasi-judicial proceeding, so the formal rules of evidence do not apply. But all testimony provided today is taken and provided under oath, so we'll swear folks in, as I said, as each case is heard. So with that, I'll turn it over to the town. The first item before we begin with the actual cases is adoption of the June 2nd, 2020 minutes. I've reviewed those. I don't have any revisions to those, so I'll adopt those as presented, and I'll turn it over to the town.
Yes, Special Magistrate, if we can we take item number D on the agenda first, violation hearing, case number 2020-006, Deborah Jarvis, 101 Bonita Drive?
Yes, sir. Are the representatives here for that? I'll go ahead and swear everyone in, so if you're gonna speak on this agenda item, or excuse me, this case number 2020-006, would you raise your right hands for me? Do you all swear affirm to tell the truth, the whole truth, and nothing but the truth? Thank you.
If I can, Officer Ranta, can you come over to the podium? And also, Officer Ranta, if I can, were you able to take some photographs?
Yes, sir, I was.
Okay. Special Magistrate, if you don't mind, if I can, let me see, Officer, let me go ahead, I'll show them to the applicant, and then...
Do you need the case file for that?
No, I
You
got
have one
that,
for
I
them?
don't know if
Okay.
you have that, I don't think you have the photographs in there, so if I can show them here, you okay, great, you can take a look at those. I think these were taken this morning?
Yes, sir.
Okay. Okay. And if I can show, Special Magistrate, these are the photographs that were taken by Officer Ranta this morning, and I will have him testify in just a minute. This is for, once again, this is 101 Bonita Drive. It's for a violation of section 67-174A and 67-177A, failure to maintain property maintenance, appearance, and failure of responsibilities of owners according to town code. And Special Magistrate, you have the file in front of you. If I can have Officer Ranta explain, I guess you're familiar with this, or first of all, Officer Ranta, you're a police officer for the town of Ocean Ridge, is that correct?
That's correct.
Okay. And if you can explain, I guess your involvement with 101 Bonita Drive.
So I was told about this possible violation at 101 Bonito. I went to go drive by the property and make contact with the homeowner. Upon arrival of the property, I saw exposed tar paper on the roof. I walked up to the front door and noticed a hole above the front door and also to the side where it looked like a vent for the attic had collapsed or deteriorated. When I went to go make contact with the front door, I noticed a rodent that went up into the attic. I knocked on the door, no answer, and then I was able, at a later date, make contact with the roommate, James Burgess, who advised that he was a renter and not the homeowner, and he said he had nothing to do with the property and it was all on the homeowner, Ms. Jarvis. I've had several contact with Ms. Jarvis over telephone, not in person. She advised that she had a roofer, then didn't have a roofer, and then a couple days later, a roofer called me stating that he had been contacted by the homeowner to get a quote for the repairs. I filled him in on the code violation and the city permits and the process, and he said he would go give a quote. From my knowledge, he was given a quote, but he probably won't be hired because of the extent of the damage and the cost. At that point, she retained an attorney. I had contact with the attorney, Mr. Mike McCormick, about the violations. He said that he would work to get it fixed, and as of this morning, it has not been fixed.
Thank you, officer. And when were you first made aware of this? What was the date?
May 4th.
Okay.
And if I may, can I ask the officer a question?
Sure thing.
Special Magistrate?
Brian, Officer Ranta, can you speak closer to the microphone, please, since
Yes.
you're wearing a mask? Thank you.
And so, Officer Ranta, based on your observation, this appears to be a violation of Town Code Section 67-174A and 67-177?
That's correct.
Okay, thank you. The town has no further witnesses, Your Honor. And also, Officer Ranta, I guess you did post the property.
I did
for this
post, I
hearing.
did, it was sent via post by the door, mail, and also I emailed the copy to her attorney, Mike McCormick.
And let the record reflect that the attorney is here in the audience today. Thank you, Your Honor. That's all the town has.
Okay.
As well as we have the administrative costs depending on, your finding.
Sure. So these photographs that were taken by the officer this morning, do you want those entered
Yes,
into the
I-
case file as Exhibit 9 then?
Yes, I do, along with the case file itself, and I have not shown that to Mr. McCormick yet.
Yep, that was my next question. If we could
Uh,
have appearances of the respondents and also show them the evidentiary case file and walk them through the documents.
Okay, and if I can I use the file that you have, so that way we know that they are looking at everything you're looking at?
And if we could switch, could we have the respondents now approach the podium so we can get them on the microphone and make their appearances?
Oh, if I could get the case file, if you could take a look at it, let me know.
Okay.
And once you get back to the microphone, sir, can you give me your name and also the name of your client, please?
Yes, good morning, Special Magistrate. My name is Michael McCormick, and I'm here on behalf of Deborah Jarvis.
Spell your last name for me.
It's actually on the screen. Coincidentally, it's the same as Mile,
Okay, got it.
M-C-C-O-R-M-I-C-K.
Got it, thank you.
Giant coincidence.
Makes it easy on me, thank you. And ma'am, your name? Thank you. Do you have any objection to the evidentiary case file that the town has provided for your review?
The only thing I hadn't seen before were obviously the pictures this morning, and then also what appears to be some sort of fee sheet. I don't know what that is. I assume it's some sort of fee
It's-
sheet, but that's all I know about it.
It's the administrative fee that the town is allowed to charge in order to bring the case to the special magistrate if compliance has not been achieved within the time frame that the town had requested it be achieved.
I understand.
So,
No objection then.
Okay, thank you. And before you begin your testimony, I will go ahead and enter into the record Composite Exhibit 1, which now includes Exhibits 1 through 9, with 9 being the photographs taken by the officer dated today. I'll enter that into the record with no objection by the respondents. And at this point, sir, go ahead and present any evidence or testimony that you have to me with regard to the violations that the town has just discussed.
Yes, Your Honor. And I apologize. Is it okay if I call you Your Honor? That's one word I'm used to, so if you're okay with that, I'm okay with
It's
that.
fine.
Okay. I was contacted by Ms. Jarvis regarding this matter, and what Officer Ranta is basically what I understood to be the issues. He came by, saw some violations, but the parts that, were not given in his testimony were that apparently the manner in which he did it is in a more of aggressive manner. She's, a lady living with her dogs and his roommate, and he comes over and he has more people going behind the house. And when the roofer called, apparently he told her he wouldn't do the job because of how the police officers handled the situation between them. That's at least my understanding. And other than that, Officer Renta gave a pretty straightforward of what happened, except for also that when him and I spoke, there were the issue with the rodent. I told him, hey, listen, this is what we're going to do. We're going to get in contact with the roofer, get you a quote, take care of the pest problem, and hopefully we don't have to go to this magistrate hearing. He said, well, see what you can do, get these things for me. We got the pest problem taken care of. Somebody came out, I think, within 5-6 days of him and I speaking, so that's no longer an issue. While it sounds terrible in testimony, it has already been resolved, so it shouldn't even be an issue for today, shall we say. The issue with the roof, however, it is rather expensive to fix the roof issues, and at this point, Ms. Jarvis has already entered into a sale contract to sell the home, and it's what we'll call, quote-unquote, a knockdown, complete demolition of the house. So we're here today to request that you give us an extension. 90 days would be requested because it has to be cleared by the bank because technically it's a short sale. And I'm also working with the bank's attorney to get this done. Obviously, the administrative fees to get us here today, we understand that, but we ask that there be no lien placed of any kind until at least we can have some sort of check-in. Like I said, requesting 90 days. Additionally, and the other reason that I asked for the 90 days as opposed to something shorter is, like I said, we have to get the bank to go ahead and agree. If you need a copy of the contract for sale, I have that now as well. I guess it makes sense to go ahead and enter this one into evidence.
Okay, you can present it to the town attorney, and he needs to review it before I see it. Any objection to that?
No, Your Honor.
So we'll enter this in as respondents, exhibit 1. And what is, while I'm looking at this, explain to me what your estimated timeline is under this contract. As you said, it's a short sale.
So because it's a short sale, Your Honor, we have to actually, like I said before, we have to have the bank's approval. Generally, it's 30 days for them to give me an answer whether or not we get an approval or not. If we don't get an approval, for example, the amount is too low, we're missing a piece of paperwork. The first general review is 30 days, give or take one way or the other. Then we have to provide the additional paperwork, or because it's a real estate sale, just like any, negotiations can be done to either bring it up, push it down to get the short sale to go through. So that's why I'm asking. The reason I'm asking for 90 days is I don't think it'll take that long. I think we will have an answer within 60, one way or the other. However, I would hate to set it for 60, come back and tell you I need another week. However, if we get it done in 90, I don't think it's going to be an issue one way or the other. Either we will have got this done or we won't at that point.
Well, and I guess, so just so I'm clear, getting it done is selling the property, right? You're not offering to make any
Correct.
repairs to the issue that's represented in these photographs taken
Because
today?
the amount to fix it, the quote that my client got was $100,000 on a house that's gonna be knocked down, doesn't make any sense one way or the other, and the buyer has already expressed that it will be a knockdown. It's also my understanding that in the same neighborhood, there is currently construction going on to another home for similar reasons that was knocked down. If there is some sort of cosmetic fix that the town, I'm sorry, again, I would refer to the corporate, that the town would like to happen, that can be a temporary fix, we're definitely willing and open to that, but to get a full roof repair is well over $100,000, and at this point, it doesn't make sense. If you saw the contract, what the house is worth as a knockdown, it doesn't make sense to put that type of money in it, especially, again, considering it's a short sale.
Right, and just so I'm clear, this question's for the officer, I just wanna make sure I understand that the pictures showing the top of the roof, the hole in the soffit underneath is right beneath the part where you can see visibly on the top of the roof, right? Okay. So,
Hold, Your Honor, my client is telling me that the hole is not right underneath it. You can tell her, it's okay.
But there is a hole, on the top, the structure of the paper is exposed, and then the gap is over to the left, it's not right underneath.
but presumably it's been caused by the same lack of roof tiles at the top? It's in the same general vicinity, I guess is what I wanted to confirm with the officer and with you all.
General vicinity, then yes.
Okay. And so the quote that you received for $100,000 is to fix, what would you estimate this to be, maybe a 5x5 area?
No, it's not like that, because once they start opening up, then it turns into a whole can of worms. And then we don't know how far back it would go, it's not just a 5x5. I could try to work on that area if that is important.
Okay,
But I'm going to be moving.
understood. What is the town's position?
Your Honor, naturally, the town's concern is that once the property is transferred, we may end up having to start the process again, depending on if we haven't liened the property. So what we would appreciate is if we give you 90 days to come into compliance, or 90 days, well, let me see if I can word this correctly. If you can somehow fix I don't know how I say it, the offending look of the violation, okay? And take care of that. And I don't quite know how that can be accomplished, because if they have to get a permit to do something, then, a roofer may look at that and go, well, look, I can't do this unless I do something else. And then that's when you start running into more money. I don't mind giving them, a period of time to kind of do that, but I'm concerned that I don't want this to drag on into the next property owner, because the next property owner, once they buy it, it may take them a period of time before they tear it down. That's my concern.
Okay.
Brian, I'm so sorry. The town clerk is requesting that anyone that's providing testimony wear a face covering, especially if they're not within 6 feet of someone else, and to speak directly into the microphone, please.
So to wear it, or?
The respondent, Ms. Jarvis, was not wearing a mask, and she,
Oh,
yeah.
okay, sorry, okay.
I'm sorry, where were we?
Okay, no, I think the concern that I have, we'd certainly like to work with you, it's just, do you think that there's a way that you can somehow kind of repair this without, without going into, I guess, without doing a complete re-roof? I saw in there the value, and then the timeframes that you mentioned are in the contract there, but my concern is that this can drag on for a period of time while you're going through, once you sell it, then the new owner buys it. It may be a period of time before they say, okay, let's knock it down.
Okay.
And we've ran into that issue before, and that's the concern that I have in agreeing to some extension to allow you to, no offense, get rid of the property, but then now it's still in the town, the neighbors are still looking at it, and it's still the town's issue, but it's not your issue.
So really, if we could get some sort of I don't want to call it a covering, but a quick fix to the roof visually, everybody would be temporarily happy if it got sold, because then we wouldn't have to look at it. And the new buyer is a developer, so my understanding, or our understanding, is that it's going to go fairly quickly. Again, that's all relative to, you know, what is quick to who, but I think that we can at least, at a minimum, look into getting it fixed. I don't personally know, I'm not a roofer, I don't know what type of permits that requires, and I'm sure somebody in this room probably does, considering we are at the town. But if there's something that can be done without a permit, my guess would be it could be done fairly quickly, and for not a lot of money if you're just putting new tile, or at least a similar colored covering on it, so that it's not it doesn't look like a scab on a roof, at least it looks.
I would
new
almost
skin.
say that anything you do is probably gonna require a permit. I just wanna mention that to you.
Okay.
So that's, to have that on the record, because I don't wanna see you here again next week, next month, doing something
What are you
without a
talking about? You
permit.
told me I didn't need a permit.
Yeah, exactly. So, that's how come, and so that's the concern that the town has, Your Honor. And once again, I wouldn't mind giving them some time to do it. I certainly understand the predicament they're in, but, this has been going on for a little while, I believe, and so, we're trying to kind of get some resolution, and I understand you don't want to put money into it, I get that, but I would think that there's some way that, something can be accomplished to make it look better.
Okay. I mean, we can definitely look into that. Obviously, I don't have an answer for you today. Some research is going to have to be done as to what can be done with or without a permit requirement. I mean, maybe there is something that doesn't require it. I don't know. I'd have to look it up. Or call one of our roofers to see if there is something that can be done quickly to resolve that issue temporarily. But other than that, I think we've said pretty much everything we need to at this point. I mean, that's why we're requesting the 90 days. We don't believe that this house will be up in very much longer than 90 days to begin with. So we ask that even if you want to set us on another hearing date so we have a deadline, we don't mind that either.
Well, you essentially just read my mind. So I'm happy to hear you say that. My concern also is legally for the town, what you're asking them, and I understand your client's position to try to rid themselves of the property. However, as the town attorney said, if we give you that time to get rid of it, and another 6 months drag out, the town then has to notice the new property owner, and the problem hasn't been solved. So in an ideal world, yes, it may be demolished quickly, but if it's not, the town is left in a position where we're at a hearing today, there's clearly a violation, and the town is left with an uncertain remedy at best. So if both sides are in agreement, what I would like to do is set this, I guess let me back up. I do find that there is good service here. It was sent certified mail and delivered. You all have appeared, which means you got notice, so I will find good service. I do see, based on the pictures and based on the testimony of the officer, as well as the information that you've testified to, that there is very clearly a violation of section 67-174A and 67-177 subpart A with regard to the condition of the roof and the underlying soffit there. What I'd like to do is require you to comply within, I guess, 29 days and set you for the next hearing, a status/fine assessment hearing. I'd like you to come back, and in that time, I'd like you to have spoken with the town's building official to see what we can do in terms of permitting and getting a more temporary fix to the solution. And I'd like to hear that at the next hearing. So if additional time is required, then we can discuss that then, but in an effort to make sure that this progresses forward, I would ask that you come back for a status/fine assessment at the next hearing, which the date is, town attorney, can you give me that date?
August 4th at 10 a.m.
So in today's ruling, I'll order you to comply by August 3rd.
What time is that at?
August
10
4th.
a.m.
You guys are gonna kill me. I'm in a mandatory conference in Palm Beach courthouse on that day. I can't possibly be in two places at once. And if it was a hearing, a regular hearing that I could move, I would tell you, but it's a mandatory status conference set by the court at 9:30.
What is the next hearing?
September 1st, I believe.
Yeah, September 1st.
Okay. What if we give you until August the 28th, or August 31st, to, I guess my recommendation is give them till August 31st to come into compliance. Hopefully, in the meantime, you can be conversing with the town to see what you can do, which I'm sure permits will be required. And hopefully you can work something out, and so then by August 31st, if compliance isn't achieved, then the fine assessment hearing will be for September 1st. Your Honor, if that's okay with you?
Yes, is that okay
Okay.
with respondents?
That is fine with us. I just wanted to clear up what you want us to get done before then, other than, obviously, ultimately, you would like us to fix the issue with the roof so it looks nice again. But are there other, if that isn't possible, short of doing the whole remodel that's $100,000, because if that's the case, and we find that out in a week, I don't mind calling your office and letting you know, hey, we've exhausted the options, the only option is it's a full
Re-roof.
re-roof, or a full re-roof of that section, which is going to end up costing more than it's worth, and then do you want to address it at that time? I just want to make sure I have a clear directive so we don't have confusion when I come back.
So I would say with, and I'm certainly not a building official, so I can speak in a limited capacity here, but I would certainly say the underside, the softening, that's a separate issue, right? That can be done regardless of the re-roofing of the structure. But what I would ask that you,
The what? I'm sorry, I couldn't hear
the
you.
soffit, the underside,
Oh, yes, okay.
right? So that's independent, I would assume, of the re-roof. I would ask that you make, and what I'm gonna expect to see at the September 1st hearing is that you come here with a good faith showing of what you've done between today and that date in terms of remedying the violation. So if you have quotes for minor repair of the structure, I would presume that you're gonna have spoken with the town's building official so that he can give you guidance on what would pass inspection, because your issue's not gonna be, I wouldn't presume, pulling a permit, it's going to be what you can actually get inspected in terms of the quality of repair. So that's gonna take coordination and communication with the town's building official. I can't speak directly to that today, so I can't give you here today very clear direction, other than you're gonna have to speak with the building official. The way that this will be structured is that, as the town attorney has recommended and as you've agreed to, compliance by 8/31, that gives you nearly 2 months to make some progress in terms of having more information to come back to the next hearing, the September 1st hearing with. If it hasn't been addressed to the satisfaction of the town at that time, I presume the town is going to ask for a fine to start running on that date. I'll have to wait to hear what you say and what you bring back at that hearing as to whether or not I'll offer you more time or give you more time, or whether we'll start a fine running then. But my best suggestion is, again, get as much done in terms of groundwork and gathering information and coming back to the town, communicating with the town about what can and can't be done. Understanding your position is to try to sell the house. So my hope is that there's some compromise there, and you can bring that back to me in September and have had at least a path forward to get it addressed in terms of appearance, rather than, apart from structural repair. Does that
I
make sense?
understand. Just as a one last clarifying and to be completely transparent, what do you want us to do if it's sold by then? We don't want to have an issue where you then are angry because we sold it 3 days beforehand. You know what I mean? Like, we want to be upfront with everybody. If there's a good chance that we get it sold by then, as that is the end goal, do you want, it's my understanding that the new buyer does know of the violation. Like, he's not,
If it's on behalf of the town, well, shouldn't say on behalf of the town, but if it's sold by then I don't think you would be involved in it anymore, and we would be addressing this to the new property owner, and hopefully they will be aware of it and realize, okay, we need to either get this fixed, or we need to come in for a demolition permit right away. Otherwise, we will go after them.
okay. I understand.
And I would agree, there's nothing we can
Yeah.
do in terms of controlling ownership or transfer of sale. That's outside of this arena for today. Do you have anything further, respondents, for me?
No, I think that's it. Do you have any more questions? Actually, give me 1 second. I just want to make sure. one last question. This may be a question that's beyond today, and maybe for the building officer of the town. But is it possible to do an owner's permit versus a standard permit to get this fixed?
My experience is that depends. If you're the owner and it's homesteaded, I think you can do that. If it's not homesteaded, I think there's a prohibition there, but that's a statutory requirement, and as you say, you should speak directly with the town and the building official.
That's understandable. Thank you, everybody.
Okay, anything further from the town?
No, just, we would appreciate if the admin fees of $177.80 could be paid within 30 days.
Understood. So in case number 2020-006, I'll make the following findings of fact, conclusions of law. I'll find that the property located at 101 Benito Drive is in violation of Town Code Section 174A and 177A. I'll require respondents to comply with these sections by August 31st of 2020. In the event that respondents do not comply by August 31st, I will ask that you reappear before me for a status/fine assessment hearing on September 1st, 2020. Is the town okay with the $25 fine, or what's the fine amount recommended for this if it doesn't comply?
Well, we would recommend something higher than $25 if we can go $75 or $100 per
Okay,
day.
in the event that compliance is not achieved, I'll impose a $100 per day fine.
Can we object to that? That's really high, over 25, quadrupling it.
Well, the statute, I'm sure you're aware, 162 allows a fine of up to $250 per day for the violation, so that, given the circumstances here, I think is a fair number. Again, the hope is you comply and that doesn't become an issue,
Right.
so.
I want to make it on the record that I'm objecting to $100 when it could have been 25.
Understood. I will go ahead and impose that fine in the event that you do not comply by August 31st. I will also grant the town's administrative costs today because you were in fact found in violation. Those administrative costs are in the amount of $177.80, payable within 30 days. And with that, you will obtain an order in the mail reflecting all of that.
Perfect.
Thank you.
And do you have a copy of the administrative fees so we can take and have the additional amount?
There's an invoice at the front.
So just pick it up on the front on the way out?
Yeah.
Okay, thank you.
Thank you.
And special mention, can you give me 1 second to check on the other 2 cases?
Yes, sir.
Oh, okay. That'll be fine. I think we've got enough chairs. Your Honor, if we can we call up Case B on the agenda, violation hearing, Case 2020-004, Inlet Plaza Condominium Association. And before we get started, we have spoken with their representative attorney, and they had requested an extension or a continuance of this hearing for 60 days. I think we are amenable to continuing the hearing until August 4th at 10 a.m. And my conversations, just so it's on the record, with the attorney as well as with the Boynton Beach Fire Marshal is that hopefully they can submit plans and things of that nature where at the August 4th meeting we can either continue it more if they're progressing or we take other action.
Okay, before we get too much further, can we get appearances and can I swear in the folks who are here to speak on behalf of 2020-004? Just you?
Yeah.
Yes, sir, your name?
Mark Stempler,
Thank you.
and I'm the attorney for the association.
You might want to speak, sorry, at the podium.
And if you could repeat that, I'm sorry, when you get back there.
Sure, it's Mark Stempler, STEMPLER, and I'm the attorney for the association.
Okay, is anyone else going to be speaking on behalf of this?
Not at this time.
Okay. Okay, so, and I was copied on an email. I didn't review anything until this morning's hearing, so as not to run afoul with any requirements of the law. But I do understand, and I see before me sitting here is a motion to continue. Has what the town attorney said, is that an accurate representation of your discussion, and are you in agreement with that?
Yes.
Okay. Okay. Okay, so what we'll go ahead and do then is, I will find, as a matter of law, that if we could, town attorney, if we could just show him the case file, we need to get the notice documents into evidence for the record to preserve
Oh,
that,
okay.
so that the continuance is valid. If you
Okay.
could show him those and go through the exhibits and ask if he has any objection, that would be appreciated.
I think, Your Honor, if we can, let me see, just the, this document. Before we get into the exhibits, because I know they have a number of exhibits that they would like to submit also. So before we get into, I guess, talking about the exhibits, if we can just confirm, if he can confirm, yes, I've got proper notice, and then let's go ahead and continue it to a date certain where no further notice will be provided to you or your client. August 4th at 10 a.m.
Yeah, that's all I'm concerned with, sir.
Okay.
So if you could just review in the case file, if you could review the notice documents and let me know if you have any objection to those documents.
We don't have an objection to the notice documents, Your Honor, as long as we're reserving all rights to contest the violation at a later time. It's just continued, then, we're okay with that.
Okay. And you're in agreement with the town attorney's comment that a continuance granted here today for August 4th, 2020 at 10 a.m. On the understanding that there will be no additional notices provided under Chapter 162. Is that correct?
Yes.
Okay. So in case 2020-004, I'll make the following findings. I'll find that notice for this morning's hearing is sufficient. I'll find that the respondent's attorney has requested a continuance. The town is in agreement to continue this case until August 4th, 2020 at 10 a.m. That's date and time certain, so as I said, no additional notice will be provided by the town, and we will get into the merits of the issue on August 4th, 2020.
Thank you.
And at this time, Your Honor, I would like to call up item C on the agenda, violation hearing, case 2020-005, the Tamarind Inc. at 6665 North Ocean Boulevard. Once again, we have had I have had some discussions with the Tamarind's attorney regarding this, and at this point in time, I think we both agree that we would, along with, I've discussed this with the Boynton Beach Fire Marshal as well, that we would like to continue this to a date certain of August the 4th at 10 a.m.
Thank you, sir. Could you state your name for the record?
Ken Khalil, attorney for the Tamarind.
Spell your last name just so I get it right.
Kaleel.
Okay, given the request for continuance again, town attorney, I'd ask that we show the case file, only the notice documents which are pulled out there for his review.
Similar objection to the inlet K. We have no objection to the notice requirements, but we'll, don't waive any rights to contest the violation itself.
Okay, and much like the case heard before you, in the event that this continuance is granted, you're in agreement that no further notice documentation will be provided by the town, that you will be required to appear on August 4th, 2020 at 10 a.m. You'll have actual notice of that date, given my communication with you here today.
Yes,
Thank you.
except I do reserve, because I have, my client left because we agreed to a continuance. If there's an issue with that date, I will inform the town attorney, and then we'll go accordingly. But for right now, I will agree to the August 4th.
Okay, understood, thank you. So similar in case 2020-005, I find that notice is good and sufficient for today's hearing. We have counsel and we had the respondent here, so the documentation shows that we've met the requirements, the town has met the requirements of 162 in terms of providing adequate notice. I will grant the respondent's request, which has been agreed to by the town, to continue this matter until August 4th, 2020 at 10 a.m. With respondent's counsel's agreement that no additional notice will be provided. If there is a conflict, please communicate with the town.
Yeah, just one comment, Your Honor.
Yes, sir.
That was, it was an agreed upon, we didn't request the extension, just so
Okay,
you know.
that's fine,
But we're
yeah.
going along with it.
Okay, so I'll revise my statement to reflect that respondent's counsel has agreed to continue this case rather than request it to August 4th, 2020 at 10 a.m. And you will get an order granting continuance in the mail, as will the prior respondent. Will communicate that with them. Anything further from the town?
No, Your Honor.
Okay. Thank you, and I don't see any other items on today's agenda, so are we set to
That's-
adjourn?
Yes, Your Honor.
Okay, we'll be adjourned at 10:57.
This conference is no longer being recorded.